with
No,
you.
no,
Give
but
me your-
then on the merits part, because your lordships also observed, and rightly so, that look, it may not be appropriate to have a piecemeal hearing. On the merits, I am a little
You are blowing hot and
handicapped
cold.
at this stage. I'm handicapped at this stage because I do not have the advantage of a response.
They had 4 months, my lord. They could have come with some decent reason for delaying the matter, my lord. This is not the
I think
reason.
not, that's a little harsh by the solicitor. Not you give additional facts. We are asking to respond to them. That's all.
10th and 17th, just I'm saying it, your lordship, keeping in mind, nothing else, your lordship, right? 3rd, 10th and 17th, I'm instructed, a little bit side to time. Not once, not twice, not thrice. That should be kept in perspective.
No, but that,
What did you say?
you see, it is not that since they had taken time, you will also take time necessarily.
I'm not saying that.
Yes, it is not a battle for adjournment going on between.
No, we have never sought
In a
that.
matter of sensitivity, a matter of.
Every matter is sensitive. Every matter is
But
sensitive.
anyway, some matter we feel is more sensitive than others. It requires a detailed
It
response.
may be sensitive for you.
It
For
is
us,
sensitive.
For us, it is definitely unusual. My lord, the way in which the Honorable Chief Minister has barged into and have
Sorry,
snatched
this is not becoming a speech, Lord. Let's
evidence
just,
of a crime is an unusual thing.
that's not fair, Lord. This is.
This is false.
She has, my lord, admitted. I'll show that.
Enforcement Directorate has
Why
multiple.
don't you proceed with the hearing?
Lordships
No, I have no difficulty. my lord.
Proceed, please.
Yes.
We are raising a preliminary objection first.
That is again, same thing.
Again, means what? This is what we have been saying from the very beginning.
So then you begin.
So we are beginning.
When I am requesting you to begin, you there are some other additional material to be brought in.
We never said we will
Okay,
not
so
begin.
may I just broadly indicate on
Yes,
behalf
please.
of the state the 3 broad grounds on which we are going to
Yes.
make submissions. The first ground.
I need peaceful sleep, Rexa.
Not in my job description.
जब जब इस धरती पर कोई पीसफुली नहीं सोता, I'll be there. The Sleep Company, India's first and only smart grip mattress. The body goes soft comfort, back go firm support. Peaceful sleep mode on. The Sleep Company.
Keep one factor in mind. State of West Bengal has also filed, my lord, and I will give the number, writ petition under 32 as State of West Bengal. State of Kerala filed writ petition as State of Kerala under 32.
You
The-
mention it.
And
the
this
state-
governor's, my lord,
You mention it when your turn comes.
I will.
When
I
you
will.
reply.
So Malloy, may I just broadly indicate the 3 heads of submission and then I will develop each
So
point.
you are for state of Bengal.
I'm for the state of West
Which
Bengal.
matter?
Which is
In both the
response
matters.
one in, no,
Both
but
the
I mean writ petition criminal 16 of 2026, President.
Yes.
16 of
Yes, you are right.
2026.
16.
Right?
Yes,
Yeah.
yes.
Now, yeah. Now the 3 broad heads are, number 1, as far as the Directorate of Enforcement is concerned, it is not a juristic personality. It is not a juristic entity. If it is not a juristic entity, it cannot maintain a petition under Article 32. This will be the first broad submission. The second is that in any case, having regard to Part 3 of the Constitution, because this is a petition under Article 32, there would have to be a breach or a violation of fundamental rights. And absent any violation of fundamental rights ex facie, because according to us, Enforcement Directorate's fundamental rights cannot be breached. So if the Enforcement Directorate's fundamental rights cannot be breached, then in our respectful submission, an Article 32 petition is not maintainable. That's the second. And the third broad head of submissions is going to be that this issue is one which relates to a very important aspect of interpretation of the Constitution of India as to whether an enforcement directorate can at all maintain a petition, and because it has to do with part of our basic structure. We will place before you the articles of the Constitution which have a design for the purposes of resolving disputes between a central government and a state government. That has a special, it's part of the architecture of the Constitution. And when you have specific provisions and specific channels for redress, those have to be followed. And on our understanding of the law, other types of redress or other forms of petitions are excluded. Now, in this context, I would just mention over here at this stage, because this will take you to Article 145 of the Constitution. So may I just request you to please take that up so that I flag the point, and thereafter your lordships can, we will get into the further details. One 145. The lordships have Article 145 of the Constitution.
Yes,
I'm just flagging it at this stage.
rule of court.
Yeah. 145(1) rules of the court, etc. Subject to the provisions of any law made for by Parliament, the Supreme Court may, from time to time, with the approval of the President, make rules for regulating generally the practice and procedure of this court, including, and then you have various sub-articles which are there. With your permission, I'm skipping those. 2. Subject to the provisions of Clause 3, rules made under this article may fix the minimum number of judges who are to sit for any purpose and may also provide for the powers of a single judge and division courts. So this is subject to Clause 3. Now, Clause 3 is really what is pertinent and important over here. The minimum number of judges who are to sit for the purposes of deciding any case involving a substantial question of law as to the interpretation of the Constitution, or for the purpose of hearing any reference under Article 143 shall be 5, provided that where the court hearing the appeal under any of the provisions of this chapter other than Article 132 consists of less than 5 judges, and in the course of the hearing of the appeal the court is satisfied that the appeal involves a substantial question of law as to the interpretation of the Constitution, the determination of which is necessary for the disposal of the appeal, such court shall refer the question or opinion of the court constituted as required by this clause for the purpose of deciding any case involving such a question, and shall on receipt of the opinion dispose of the appeal in conformity with such opinion. So I'll place the entire article. No judgment shall be delivered by the Supreme Court save in open court, and no report shall be made under Article 143 save in accordance with the opinion also delivered in open court. Sub-Article 5, no judgment and no such opinion shall be delivered by the court save with the concurrence of a majority of judges present at the hearing of the case. But nothing in this clause shall be deemed to prevent a judge who does not concur from delivering a dissenting judgment or opinion. So let me just state the point, and then your lordship in the fullness may consider as to whether, but I think it's important for us to flag this issue, because then I don't want to be told that you should have mentioned this at the outset. This question, you see, when we open and when we explain the case, and your lordship in your wide experience already knows, there are a large number of departments, both as far as the central government is concerned and in our states are concerned. Huge number of departments. Now, these departments are there under various forms, rules of business, etc., to carry out and conduct business. The question which arises is, can a department, which is not a body corporate, because in many situations, for example, Parliament sets up, say, something like the Securities Exchange Board of India. When we look at that statute, you will find that it has an express provision which says that an entity such as this has a corporate personality and it can both sue as well as be sued. When we look at the Enforcement Directorate, it is nothing beyond just a department of government. And that the central government had discretion to establish, we'll place those provisions. Now, when you have a department, it doesn't have any to sue by itself. Now, this becomes very, very important having regard to the larger federal structure and the interpretation of the Constitution. Because your lordship knows that there is, for example, Article 131. Because what I'm going to develop later on is this, that when you have a department, say, of the central government, equally you could have a department of the state government. That department of the state government, let me start with department of the state government, is nothing but the state. So what you essentially have is a situation where this is the central government which is suing. And it is the central government is suing and asking for relief in respect of Part 3 of the Constitution of India, which are fundamental rights. Now, this itself is a very interesting and an issue which the court will have to look at as to whether you can have the central government complaining that, look, as far as I am concerned, I am the state and I am finding that the state has to, on our broad reading and understanding of the law, is the one which has to guarantee fundamental rights and non-violation of fundamental rights broadly to the citizen, but your lordships have correctly said that it is to persons. So persons may be citizens, may not be all of them citizens. Even if you're a foreigner, there may be certain fundamental rights which you are entitled to. But nevertheless, it has to be some form of personhood which this particular entity as a department doesn't have. Now, when you look at the whole situation across the country, what you will find is that there are several such departments. And therefore, the real issue, why am I starting by mentioning 145.3 is that this is something which, on our understanding, the Constitution itself says that when issues of this kind of importance arise, there ought to be a minimum of 5 judges who decide the case. So this is why I thought I should just flag this, because this is surely an issue which really needs to be referred to, even on the question of maintainability, even on the question of, then of course merits is a secondary thing. But this itself, the Constitution mandates that issues like this, which involve the interpretation of the Constitution, can the union government complain of a Part 3 violation? Can the union government come over here and say that there is that a 32 petition at my instance is maintainable? If this happens, broadly, what a court of appropriate bench strength will have to consider is that if we allow this, then the situation can arise, may not arise, where you have a surfeit of 32 petitions which are being used by one department against another department across states. It could happen in some situations between 2 states. It could happen in some situations between the state and the center, or as here you have as between the center and the states. So this issue, I would respectfully, I'm just stating it, then we take you to the case law, etc. as necessary. But I thought I should mention this at the outset, because this is really to be appropriately decided by a panel of 5 learned judges, is my respectful submission. Now, my lords, let me just indicate to you first as to who the first petitioner is, which is the history of the Enforcement Directorate. So I'll just give you some background, and then I'll request the court master to handle the Foreign Exchange Management Act. Now, the Directorate of Enforcement, your lordship may just note, was first formed by an executive fiat on the 1st of May, 1956. And it was an enforcement unit of the Department of Economic Affairs of the Union government for handling exchange control violations under the then Foreign Exchange Regulation Act of 1947. So that's one thing which your lordship, just historically, that is the background. Then your lordship may note that at that particular time, so initially it was an enforcement unit. Then the enforcement unit in or about 1957 was renamed as an enforcement directorate. And in or about 1960, the administrative control was moved from the Department of Economic Affairs to the Department of Revenue. So it's really a department, as you will see, within a department, to the Department of Revenue. Then the Foreign Exchange Regulation Act of 1947 was repealed by the Foreign Exchange Regulation Act of 1973. And on our understanding, for a brief period between 73 and 1977, there was a renaming of the Enforcement Directorate, and it came under the administrative jurisdiction of the Department of Personnel and Administrative Reforms. So it still remains a department. Now we come to Foreign Exchange Management Act, and here I just request your lordship to pick up Section 36 of the Act first, please.
Yes.
Yes.
Your lordships have FEMA?
Yes.
May I invite attention to Section 36?
Yes.
Now, your lordship has that.
Yes.
Now, please see, this is a chapter which is chapter 6. Your lordship has that. And then it says Directorate of Enforcement. So I'll be placing this before you. Directorate of Enforcement, section 36, subsection 1. The central government shall establish a directorate of enforcement with a director and such other officers or class of officers as it thinks fit, who shall be called officers of enforcement for the purposes of this act. So there's a mandate to the central government under this provision to establish a directorate of enforcement. Without prejudice to the provisions of subsection 1, the central government may authorize the Director of Enforcement or an additional Director of Enforcement or a Special Director of Enforcement or a Deputy Director of Enforcement to appoint officers of the enforcement below the rank of Assistant Director of Enforcement. And subsection 3, subject to such conditions and limitations as the central government may impose, an officer of the enforcement may exercise the powers and discharge the duties conferred or imposed on him under this act. Now please see section 37, power of search and seizure. The Director of Enforcement and other officers of enforcement not below the rank of Assistant Director shall take up for investigation a contravention referred to in section 13. Without prejudice to the provisions of subsection 1, the central government may also, by notification, authorize any officer or class of officers in the central government, state government or reserve bank not below the rank of Under Secretary of the Government of India to investigate any contravention referred to in section 13. The officers referred to in subsection 1 shall exercise the like powers which are conferred on income tax authorities under the Income Tax Act 1961 and shall exercise such powers subject to such limitations and laid down under that Act. 37A, special provisions related to assets held outside India in contravention of section 4. Upon receipt of any information or advice, if authorized officer prescribed by the central government has reason to believe that any foreign exchange, foreign security, any immovable property situated outside India is suspected to have been held in contravention of section 4, he may, after recording the reasons in writing, by an order, seize value equivalent situated within India of such foreign exchange, foreign security, or immovable property, provided that no such seizure shall be made in a case where the aggregate value of such foreign exchange, foreign security, or any immovable property situated outside India is less the value as may be prescribed. The order of seizure, along with the relevant material, shall be placed before the competent authority appointed by the central government, who shall be an officer not below the rank of the Joint Secretary of the Government of India by an authorized officer within a period of 30 days from the date of such seizure. The competent authority shall dispose of the petition within a period of 180 days from the date of seizure by either confirming or by setting aside the order after giving an opportunity of being heard to the representative of the Directorate of Enforcement and the aggrieved person. And then there's an explanation with which, with your permission, I'm skipping. Then subsection 4. The order of the competent authority confirming seizure of equivalent assets shall continue till the disposal of the adjudication proceedings. And thereafter, the adjudication authority shall pass appropriate directions in the adjudication order with regards to the further action as regards the seizure as made under subsection 1. Then there's a proviso, subsection 5. Any person aggrieved by orders passed by the competent authority may prefer an appeal to the appellate tribunal, and nothing contained in section 15 shall apply to this section. Then empowering, 38, empowering other officers. The central government may, by order, and subject to such conditions and limitations as it thinks fit to impose, authorize any officer of customs or any central excise officer or any police officer of any other officer of the central government or a state government to exercise such of the powers and discharge such of the duties of the Directorate of Enforcement or any other officer of enforcement under this Act as may be stated in the order. And subsection 2, the officers referred to in subsection 1 shall exercise the like powers which shall be conferred by the income tax authorities under the Income Tax Act, subject to such conditions and limitations that the central government may impose. Then we come into another chapter, which are the chapter 7 and the miscellaneous provisions. So the reason why establish a directorate of enforcement. Now, it may do so, it may not do so, so the language is mandatory. In our case, of course, there is a directorate of enforcement. Now, the first thing which is completely missing, so what is it, is the question I ask myself. What is this directorate? According to us, it's an organizational limb or a department of the central government and nothing else. And, sorry.
Yes.
So what you have here is, this is really a directorate. So for organizational purposes, for identifying as to who or what can do what items, you have officers which are there under this particular directorate. But it is no, first point is over here, there is nothing under statute, because you also should see, if you are creating a body corporate, it would have, on our understanding of the law, to be done by Parliament. It is Parliament alone which can create this. It can't be done by delegated legislation, or it can't be done by the by the central government, which is a delegate of the legislature. So here, the entire scope of this particular chapter is authority to the central government or power to the central government to establish a directorate. What it doesn't do is more important for our purposes, for the purposes of the present point which we are canvassing. It doesn't confer a right to sue. So this is my first respectful submission, that a right to sue has to be expressly conferred on a directorate. One. Number two, again, something which is absent, it does not create a body corporate. Because someone may be able to argue, the usual design of the statutes is that it creates a body corporate, and its body corporate will have a right to sue and be sued. I am here on the right to sue. So as far as right to sue, so body corporate is also very, very important. The reason why it is not a body, there are two aspects to it. Right to sue, my submission is, has to be expressly conferred, and it has not been done. If the right to sue has not been done, it cannot, in our respectful submission, maintain an Article 32 petition, because it doesn't have a right to sue. Now, there's a second facet to it. Apart from it not being maintainable in the sense of right to sue, the fundamental right, which is essential for Article 32 to be invoked, has to be, according to us, by a person. It may be by a natural person, it may be by a legal corporate entity. But if you have a situation where you are neither a juridical person nor a natural person, again, you do not have a right to sue. Now, I might just mention for completeness that as far as the Enforcement Directorate is concerned, yes, that's okay. Yeah. You may just also note, Malot, but because just for completeness, that there is the Prevention of Money Laundering Act 2002. And here, there is Chapter 8, which is with respect to authorities.
PMLA.
Chapter 8, beginning with sections 48 onwards. So just for completeness, I'm sorry. These responsibilities of authorities, while the book is being handed over, you may just note that I'm instructed is exercised by the Enforcement Director. So you must just know that the PMLA is but again, under the Prevention of Money Laundering Act 2002 as well, there is no juristic personality which is conferred. So there may be responsibilities, designation of power, authority to be exercised, but there is no juristic personality conferred. and there is no right to sue conferred. Now I come to another point, which is to say, the book may be handed over, your lordship may just have a look at that.
Yes. Chapter 8 you will.
Sorry?
Chapter 8 you referred.
Yes, you may just note that. We are really looking at the absence of provisions rather than the positive element.
If there is absence of provision, we did not look into the.
Sorry?
We can only say there is no provision.
No, I'm just pointing out this is the provisions for authorities. The provisions for, because I accept, I have indicated to the court that it is the Enforcement Directorate, although department is constituted under FEMA, which your lordship has seen. They have been given additional responsibilities under the Prevent Money Laundering Act. So the point I'm making here is that even under this statute, which confers additional responsibilities when you are and powers and duties, there is no notion of a juristic entity under this provision, and equally there is no notion of a right to sue. So these two are absent. So your lordship is quite right in the sense I can't show anything because it's absent. Show it to me from the list. Just a second. Now, my lord, sorry. Now, there is some assistance to be gained from a decision of this court reported at 2003, volume 3, SEC 472. And the title of that case, thank you, is Chief Conservator of Forests versus Collector.
2003, volume
3, SEC 472. Your lordships have it?
Yes.
Now, may I just, before I come to the relevant portions, in the sense of this, may I just give you, read some of the introductory paragraphs first. Please just have a look at page 476 of the report. Justice Kadri said, these two appeals are from a common judgment of the division bench of the High Court of Andhra Pradesh in writ petition so-and-so and appeal suit 2291 of 1986. The appeals arise in the same facts, and one set of parties is common. The matter of litigation is an extent of so-and-so acres in such and such district in the erstwhile Nizam's estate of Hyderabad. After accession to the Nizam's state of Hyderabad, with the Union of the Andhra Pradesh abolition of Jagir's regulations, so-and-so, hereinafter referred to as the regulations, came into force. Under the regulations, all Jagirs, including Prol, Jagir, stood abolished from the date of their administration stood vested in the state. Raja S.V. Jagannath Rao was the last Jagirdar. Respondents 3 and 4 are the legal representatives. It is the case of the Patedars that when the state took over the Jagir, the forest department of the state took under its control the forest land at measuring so many acres. However, the land comprised survey number 11 of Asadpur village measuring 1523 and survey number 118, such and such village as measuring 9,000 acres remain the Raja as his patta land. Soon thereafter, a notification under section 29 of the Andhra Pradesh Telangana Area Forest Act 1935 was issued on 4th of December 1950. The notification enumerated 14 villages comprising an extent of 93,000 acres of Kolhapur Taluk, which is named as the Kolhapur Range. It appears that the notification under section 30 of the Forest Act was also issued, but the notification is not on record. In the year 1953, a resurvey of the erstwhile Jagir was conducted. The land in question, namely survey number old, was assigned survey number 11 and survey number 41 old was assigned survey number 168. However, the finalization of the survey was done in 1962. The Patidars filed an application under Section 87 of the Andhra Pradesh Telangana Areas Land Revenue Act.
All these facts are not required, you come straight.
You're right. So then just have a look at paragraph, just have a look, Your Lordship will see para 12, but just give me a moment of this.
It needs to be noted, yes.
Yes, it needs to be, yes, Your Lordship, sir, para 12?
Yes.
Yeah, may I take you to para 12? It needs to be noted here that a legal entity, a natural person or an artificial person can sue or be sued in his or its own name in a court of law or a tribunal. It is not merely a procedural formality, but is essentially a matter of substance and considerable significance. That is why there are special provisions in the Constitution and the Code of Civil Procedure as to how the central government or the government of a state may sue or be sued. So also there are special provisions with regard to other jurisdiction persons specified as to how they can sue or be sued. In giving a description of a party, it will be useful to remember the distinction between misdescription or misnomer of a party and misjoinder or non-joinder of a party suing or being sued. In the case of the misdescription of a party, the court may at any stage of the suit proceeding permit correction of the cause title so that the party before the court is correctly described. However, a misdescription of a party will not be fatal to the maintainability of the suit or proceedings. Though Rule 9 of Order 1 CPC mandates that no suit shall be defeated by reason of the misjoinder or non-joinder of parties, it's important to notice that the proviso thereto clarifies that nothing in that rule shall apply to non-joinder of a necessary party. Therefore, care must be taken to ensure that the necessary party is before the court, be it the plaintiff or the defendant. Otherwise, the suit or proceedings will have to fail. Rule 10 of Order 1 CPC provides remedy when a suit is filed in the name of the wrong plaintiff and empowers the court to strike out any party improperly joined or impleaded as a necessary party at the stage or at any stage of the proceeding. Then the question that needs to be addressed is whether the chief conservator of forests as the appellant petitioner in the writ petition appeal is a mere misdescription for the state of Andhra Pradesh, or whether it is a case of non-joinder of the state of Andhra Pradesh, a necessary party. In a list dealing with the property of the state, there can be no dispute that the state is a necessary party and should be impleaded as provided in Article 300 of the Constitution and Section 79 of the CPC in the name of the state Union of India, as the case may be, lest the suit will be bad for non-joinder of necessary party. Every post in the hierarchy of the posts of the government set up from the lowest to the highest is not recognized as a juristic person, nor can the state be treated as represented when a suit or proceeding is in the name of such offices or posts of officers holding such posts. Therefore, in the absence of the state in the array of parties, the cause will be defeated for non-joinder of a necessary party to the list in any court or tribunal. We make it clear that this principle does not apply in a case where an official of the government acts as a statutory authority and sues or pursues further proceedings in its name, because in that event, it will not be a suit or proceeding for and on behalf of the state Union of India, but by a statutory authority as such. Under the scheme of the Constitution, Article 131 confers original jurisdiction of the Supreme Court in regard to a dispute between two states of the Union of India, or being one or more states and the Union of India. It is not contemplated by the framers of the Constitution or the CPC that two departments of a state or the Union of India will fight a litigation in a court of law. It is neither appropriate nor permissible for two departments of a state or the Union of India to fight a litigation in a court of law. Indeed, such a course cannot but be detrimental to the public interest, as it also entails avoidable wastage of public money and time. Various departments of the government are its limbs, and therefore they must act in coordination, not in confrontation. Filing of a writ petition by one department against the other by invoking the extraordinary jurisdiction of the High Court is not only against the is the most important part in para 14. Please.
Para 16.
Yeah, I'll come to 16 in a moment, but
Para 16, I have already read.
para 14, have your lordship seen that filing?
14 also, I have underlined also filing of a writ petition by one
Yeah,
department.
by one department against the
so-and-so.
other by invoking.
Para 16 also I have marked.
Yes.
Where the
Now,
court
now
says,
I look like. So, my lords, yeah.
the fact is that state of Andhra Pradesh was not a petitioner, therefore writ petition was not maintainable.
Yes.
It is over.
So,
Please
may I
come
just,
to the next judgment.
yeah, may I just place that paragraph 16? Sorry.
She's assisting.
But don't look like that. No, it's not a case for laughing.
Sorry. Sir.
Don't look as if you are bewildered. If at all you are bewildered, maybe by this side or this side, not. I have utter dislike for this gesturing by the lawyers when the court is putting question. Ma'am, please find.
Yeah. So, my lords, may I just place para 16? Just for completeness on my part, I'm obliged that your lordship has already
Yes.
zeroed in on the relevant portion. Now, reverting to the facts of the case in hand, we are of the view that after the said statutory order of the Commissioner of Survey, Settlement and Land Records, the matter should have rested there. We have therefore no hesitation in coming to the conclusion that it was not only inappropriate but also illegal for the Chief Conservator of Forests, though he might have done so in all good faith, to have questioned the order of the Commissioner of Survey, Settlement and Land Records before the High Court of Andhra Pradesh in writ petition so and so. The Chief Conservator of Forests as a petitioner can neither be treated as the state of Andhra Pradesh, nor can it be a case of misdescription of the state of Andhra Pradesh. The fact is that the state of Andhra Pradesh was not the petitioner. Therefore, the writ petition was not maintainable in law. The High Court, had it deemed fit so to do, would have added the state of Andhra Pradesh as a party. However, it proceeded, in our view, erroneously, as if the state of Andhra Pradesh was the petitioner, which, as a matter of fact, was not the case and could not have been treated as such. As the writ petition itself was not maintainable, it follows as a corollary that the appeal by the Chief Conservator of Forests is also not maintainable. We are unable to accept the contention of Mr. Amareshwari that merely because an officer concerned had obtained.
You're all set to start your career in the rapidly growing field of AI, but worried that your CV isn't up to the mark? Don't worry, we have a masterclass just for you. In under 3 hours, you'll find
Permission granted to the authority concerned might be a permission to file an appeal, which cannot reasonably be construed as an authorization to file an appeal in his own name, contrary to law. It could only be a permission to file an appeal in the name of the state of Andhra Pradesh in accordance with the provisions of the Constitution and the CPC. We may also record that in spite of the Patidars taking objections to that effect at the earliest, no steps were taken to substitute or implead the state of Andhra Pradesh in the writ petition, in the High Court, or in appeal in this. So, my lords, and then now we shall deal with civil appeals, so and so, so and so, so and so. So, my lords, I would respectfully submit that the Chief Conservator of Forests versus and others versus the collector and others is authority for 2 or 3 propositions which we are canvassing. The first of those is, Now, my lords, with your permission, may I just request the court to just pick up for a moment the Constitution. The Constitution. This one.
Yes.
I have it. I'm sorry. Now, if your lordship, since they were referred to in the course of this judgment, just please take up for a moment 2 articles. Please see the Constitution. Because this is, when I go into that 145(3) question, these are the articles which will have to be construed and according to us authoritatively by a bench of appropriate strength. So may I invite attention to Article 300, please. Article 300. Your lordships have?
Yes.
suits and proceedings. And at a certain level, with your permission, I'm going in reverse. I'm starting with 300, then I'm taking you to 131, and then I'm taking you to part 3. Now, your lordships have suits and proceedings. 300. The government of India may sue or be sued by the name of the Union of India, and the government of a state may sue or be sued by the name of the state, and may, subject to the provisions which may be made by Parliament, by Act of Parliament, or of the legislature of such state enacted by virtue of powers conferred by this Constitution, sue or be sued in relation to their respective affairs in the like case as the Dominion of India and the corresponding provinces or the corresponding Indian states might have sued or be sued in if this Constitution had not been enacted. If at the commencement of this Constitution, A, any legal proceeding pending to which the Dominion of India is a party and the Union of India shall be deemed to be substituted, any legal proceedings are pending before a province, etc., the corresponding state shall be deemed to be substituted for the province of the Indian state. This is a very, very important provision, which, of course, our judgment in Conservator of Forests looks at. Then, you see, I'm just pausing here for a moment. Why does this have to do with federalism, etc.? Let us see 131 for a moment.
This point was decided in that Tamil Nadu governor's issue. When the issue was decided by 2 judges bench, this point was agitated.
Which is, I'll just
That Tamil Nadu versus governor issue versus President of India.
which issue on locus?
No, this 143 issue. Whether it was decided in that matter?
Only about the
That was not the issue by the reference.
Was it?
No, it was never issued. Even in a contest between the state and central, or the governor or the state legislature and the President of India, this issue was not decided. Yes, proceed. Just as a matter of fact, I wanted to know.
And it was an Article 32 petition which was entertained at the behest of the state.
So where I'm
So that you see,
Yeah.
this will creep in. Therefore, I am asking this so that
no, I am
you are alive. What is it?
no, I'll check. We'll check that up. I'm not very familiar with that judgment, but I'm just indicating to you here. I have now placed Article 300. After having placed Article 300, which your lordships have seen, as to how the state or the central government is to be sued. The government of India may sue or be sued in the name of the Union of India. It can't sue or be sued in the name of the Enforcement Directorate. I'm sorry. I mean, that's an implied prohibition over here, which is rather elementary. But now I take you to Article 131, which is very, very important, because the Constitution has provided a scheme when you want to proceed against, say, another constitutional part of our federation, which is the original jurisdiction of the Supreme Court. Please see that, Article 131.
Yes.
Your Lordship, may I place 131? Original jurisdiction of the Supreme Court. Subject to the provisions of this Constitution, the Supreme Court shall, to the exclusion of any other court, have original jurisdiction in any dispute, A, between the Government of India and one or more states, or B, between the Government of India and the state or states on the side and one or more states on the other, or C, between two or more states, if and insofar as a dispute involves a question whether of law or fact on which the existence or extent of a legal right depends, provided that the said jurisdiction shall not extend to a dispute arising out of any treaty, agreement, covenant, engagement, sanad, or other similar instrument, which, having been entered into or executed before the commencement of this Constitution, continues in operation after such commencement of such, or which provides such jurisdiction shall not extend to such a dispute. And then your lordships will just have a look at a moment. Just give me a moment. Now, sorry, may I just make my submission now on a reading of 131 and Article 300. Now, I'll take you also to those rules, but just on the constitutional provisions at this stage. It is our understanding of the law that in the original jurisdiction of the court is in respect of this solving or not solving, but determining disputes between federation, central government and states, one or more states on the other hand, state and state, and states or states on one hand and the central government on the other. Now, this Article 131 jurisdiction, when read with Article 300, prescribes the exact manner in which the entity will sue. And this is central, actually, to the whole concept of a federal form of governance. And why is it so? When you have a suit and an original suit which is instituted, it is to be expected, a huge number of checks and balances. There are systems under whichever the rules of business are, which govern, given the department which seeks to raise it, through which the matter progresses internally within the government. So take a state government wants to file a suit under Article 131, say against the central government. Then there are a huge number of ramifications and authorities and factors which will weigh into the consideration as to whether a suit should be filed at all. Well, and if so, whether it should be filed, on what issues it should be filed. This is the safeguard because the framers of the Constitution and the Constitution as it stands realize that this is a very delicate issue. Because after all, you are having two units or the central, two or more units under the federal structure, which are contesting. So you have 131 and you have 300. If this is the converse situation, if some department of government is allowed to just file and institute a proceeding over here, it goes without any of the checks and balances which would visit Article 131. You will just have some department which says that let us sue, let us file a 32 petition, let us file a 226 petition. And this completely undermines respectful submission, the federal structure, which is part of the basic structure of the Constitution. Yes. Now, just for now, while you are considering this, there will be another article of the Constitution also on this aspect, which I am just mentioning to you so that for completeness. So you have Article 262, which I must mention because that's part of it's a single constitutional scheme. So please just have a look at it. Just basic for completeness. 262 under the subheading Disputes relating to waters. Adjudication of disputes relating to waters of interstate rivers or river valleys. Parliament may by law provide for the adjudication of any dispute or complaint with respect to the use, distribution or control of waters of or in interstate river or river valley. Notwithstanding anything in this Constitution, Parliament may by law provide that neither the Supreme Court nor any other court shall exercise jurisdiction in respect of any such dispute or complaint as is referred to in Clause 1. So this becomes a very important carve out because we now have an Interstate Disputes Act this becomes a carve out of 131 because your lordships have said notwithstanding anything in the constitution. This particular article has been interpreted by this court to mean that in relation to these type of matters, state water disputes, original jurisdiction would lie with the tribunal constituted under the Interstate Water Disputes Act. But as far as Article 136 is concerned and judicial review are concerned, those being inherent part of the basic structure as well, your lordships have retained to yourselves Article 136 jurisdiction in the case of an interstate water dispute, but not the original dispute. An original action has to be subject to this carve out if it's a water dispute in terms of the parliamentary statute. Otherwise, it has to be under Article 131. Now, please just take up the Supreme Court rules. Part 3.
Yes.
Now, in part 3, your lordship will have order 25.
Yes.
Now here, I'm not going to read the whole of it, but I'm just placing it because this is in respect of original suits.
That 131.
Yes. So you have parties to suits, two or more plaintiffs may join in one suit in whom any right to relief in respect of or arising out of the same act or transactions or series of act or transactions is alleged to exist. So it could be one or more states. It could be the central government and one or more states. It can be a situation where it is just in the singular, just one state against others. It could be just the central government against one or more states. So those are the kinds of situations which you have. So initially there's parties, then two or more defendants under Rule 2. The court may at any stage of the proceeding, either with or without an application of either party and on such terms as the court may appear to the court to be just, order the name of the plaintiff or the defendant improperly joined to be struck out, etc. And then, there are further which will have seen in part 3 itself, further rules with regard to plaints, issue of service of summons, written statement, set off, and counterclaim. And then it goes on for these type of original suits and hearing of suits, all the way up to order 37. Then you have a separate chapter, please see that. Part B, petitions under Article 32 of the Constitution.
What are you referring to this?
No, I'm referring to this to say that there is a specific,
Safeguard.
yes.
Checks and safeguards are there.
Yes, so this is the manner. If the union, I'm saying that
Article 32 petition is allowed in this way, there will be no checks and safeguards.
That's what I'm obliged. That is certainly one of our points. But what we are pointing out is that there is a constitutional scheme for an original suit, and that constitutional scheme is expanded upon by procedural provisions under the Supreme Court rules for a suit and a plaint, in contradistinction with Article 32, which is Part B under the same Supreme Court rules, beginning with Order 38. Please see that. Order 38 deals with petitions under Article 32 of the Constitution.
Yes.
This is a completely different type of procedure. This is not a procedure. This is a procedure available to the citizen or to a legal person.
Yes.
Your Lordship has petitions, Part B.
Yes.
Petitions under Article 32 of the Constitution of India. And then it has Article 38, applications for enforcement of fundamental rights relatable to Article 32 of the Constitution. And then, of course, the powers which your lordships can exercise in terms of the types of writs. And then there is a separate heading for public interest litigations as well. And then it goes into C, which is applications for transfer of cases. That's a separate thing. We're not concerned with that. Order 39 onwards. Transfer of criminal proceedings, etc. Then D, with order 42 is references under Article 143. Please have a look at that. So there's a structure, there's a form, there's a manner in which proceedings are required to be instituted if you are under 32. And there I am obliged to that observation which your Lordship made. A 32 petition would not go ordinarily. Just say there are so many when a state decides to go against the union. I'm giving you an illustration. There will be so many considerations, my lords, which are thought through. It's not just some department, some officer goes across, says, all right, you take this